in the National Youth Service corruption case have had a reprieve as the High Court Judge Hedwig Ongudi has granted them bail. Each of the over 40 suspects has been given a bond of 5 million shillings and a surety of 2 million shillings alongside a cash bail of 1 million shillings cash bail. Francis Ontomwa is on that case and now joins us from Milimani Courts, Nairobi. Ontomwa, good afternoon. What are the conditions for this bail?
Well, actually, that ruling has already elicited here mixed reactions. It is a bag of mixed fortunes for the NYS suspects, the 40-plus NYS suspects who've been in police custody for almost 3 weeks now, of course, touching on the allegations that were leveled against them. To a large extent, it's a reprieve. Speaking to the lawyers here, they are saying it's a huge reprieve there because this is what they've been pushing from the onset, and now it has been granted by the court. But of course, coming with very stringent conditions, and those are some of the conditions that have already elicited quite a bit of reactions here. Earlier on, there were clear and rather strong indications that the top suspect to this NYS scam will be appearing here in court. There was an indication that Lililan, Omollo, the suspended PS for Youth Affairs, and also Richard Ndubai, the NYS director, will be here in court. But then that was not going to happen. They were not in court, and it was an advocate affair, of course, listening to what Justice Hedwig Ongudi gave here in court. And therefore, that reprieve has already had reactions here. And I want to bring in one of the advocates for the family, or for the families of the suspects of the NYS saga here to give us his quick reaction about this entire development today. Karibu sana, Wakili Cliff Ombeta.
Thank you for having me.
You were in court pushing for this huge agenda to get bail, and it has been granted. What's your reaction?
Bottom line is we're happy. We're happy now that we have bond, because once you have bond, then in case you want any other modifications and any other alterations done to the bond, you can always have a starting point, rather than when you're not having any bond and then you cannot make any other move.
But then the bond has not come easy. It has come with very stringent conditions. First of all, we are talking of a bond each to give 5 million. There is the surety of 2 million, the cash bill of 1 million. You think it's too tough for your clients?
Let me say the initial issue about the toughness of the matter is the fight that we had with the prosecution. Them asking for the bail terms not to be granted to us or not to get any bond at all by saying that we are a security risk and all those things. Those are the things that we had to overcome and to fight. But then the law has prevailed and the judge has actually granted us bond and said that there was no material placed before her that could be able to say or to condition her not to give bond. But in any case, the terms have been given. They are strict. We cannot say anything less than that. Surety, when you bind yourself to the tune of 5 million, that means then that in case you abscond, you have to pay to the Republic or to the court about 5 million shillings or something to that value. And then you have got to get a surety of 2 million each. That then starts being the problem, because looking at the Ngiritas, I have got about 4 of them who are siblings and plus one of them who is a wife, so there are 5 of them. Each has to bring a surety of 2 million shillings each. And then they have got also to pay a cash bill of 1 million shillings each. That is again another 5 million shillings. Then they have to deposit passports. Then they have to report. Those conditions are not easy to meet. But then we have run it by our clients. We are waiting for reactions for some of them. Some of them are saying they're capable of doing that and they have started processing. But some of them are still wondering on how they can be able to raise those terms and conditions or how to meet them. And then there are those ones who have now indicated to us that they are not able to be able to meet these conditions. So what are we going to do? The High Court in its wisdom has granted the lower court, the Chief Magistrate Court, permission or authority to be able to review the bond terms if at all there are any applications made. So tomorrow we will start by making applications for those ones who are not able to meet the terms and to see whether the variations can be able to be according to Article 49 of the Constitution.
All right. Thank you, Cliff.
Yes.
Thank you, Cliff. Cliff Ombeta there, one of the defense lawyers, of course, giving his reactions to what has transpired today. And as he puts it quite clearly, it's not over until it's over. They are still contemplating of taking some bit of action regarding what has transpired today. And of course, this now opens the page for a major judicial showdown that will be happening here at the law courts, given that this matter continues to attract saturated coverage here in Kenya. And of course, we will still be sticking around here to ensure that you have all the updates as they happen. Ashley.
All right, many thanks there, Francis Ontomwa, coming live from Milimani Courts. Now, we just want to listen in to some of the rulings that took place earlier on.
It is not disputed that some of the applicants and accused in the related matters are senior officers in the public service, while others are not. It is also not disputed that the applicants and their co-accused are facing serious charges involving billions of shillings. The fact is that the case is yet to be heard for anyone to know who is guilty and who is not. The court, as an arbiter, should be seen to take a neutral stand in this matter until the opportune time when it renders its determination after hearing all the evidence. All in all, I find that the respondent has not satisfied this court, that the applicants and their co-accused should not be admitted to bail. Even as I grant bail, I'm alive to the seriousness of the charges the applicants and co-accused are facing. I also note that the total number of the applicants and co-accused is about 41, and they range from senior government officers to junior officers in the ministry and various departments. All these factors must be taken into account so that the terms and conditions of the bail bond cut across the spectrum. I therefore allow the application and grant bail bond to the applicants and all their co-accused on the following conditions.
All right, KTN News Desk takes a short break, but we still have